All right, let's dive straight into this explainer and unpack a truly fascinating constitutional court case. We're looking at a dispute that pits historical justice directly against a multi-billion rand fishing industry. It's the 2004 landmarks judgment in Bato Star Fishing versus the Minister of Environmental Affairs and Tourism. Now, you might be thinking, okay, a case about fish. But actually, this isn't just a story about fish. It's a profound look at how a nation in transition uses the law to correct deep structural inequalities from its past, all while desperately trying to keep a massive, highly fragile economic engine running smoothly. So if you've ever wondered how courts manage to balance morality, history, and economics without completely derailing an entire industry, well, you're definitely in the right place.
To really grasp the massive stakes we're dealing with, we first need to look at the South African deep-sea hake sector. We are talking about a highly lucrative industry that generates a staggering 1.45 billion rand per year in sales. And it definitely doesn't stop there. This is an industry with a fixed capital investment of around 5.4 billion rand, and it employs roughly 8,000 workers directly. It's incredibly capital and labor intensive, relying on massive ships, huge processing plants, and complex international supply chains. And historically, because of South Africa's past, this entire sector was pioneered and dominated by just a handful of white-owned companies. So when the government steps in to hand out the legal rights to catch these fish, they aren't just handing out pieces of paper. They are literally handing out millions of rand in economic opportunity. As you can imagine, that is a perfect recipe for some serious conflict.
Here's our roadmap for today. We'll cover the deep-sea hake dispute, the mandate for transformation, the reasonableness test, the separation of powers, and finally, the final verdict.
Section 1. The deep-sea hake dispute. Let's see how this whole controversy actually ignited.
The conflict kicked off when the government shifted to a 4-year quota system for the 2002 to 2005 fishing seasons, aiming to create long-term stability while urgently transforming the industry. And the core grievance here was just so stark. Bato Star Fishing applied for a massive quota increase. They asked for 12,000 tons of hake. To put that in perspective, that was more than 12 times their previous allocation. But instead, they got a mere 856 tons. Now, Bato Star was a relatively new empowerment company formed specifically to help rectify historical imbalances, so they felt totally shortchanged. They argued that the chief director in charge of quotas completely ignored the legal mandate to transform the industry and give new, historically disadvantaged entrants a genuinely fair slice of the pie. So entirely unhappy with the result, they sued the minister.
Section 2. The mandate for transformation.
To understand why the chief director handed out the quotas the way he did, we really have to look at the incredibly heavy, competing legal mandates the government operates under. The chief director was navigating the Marine Living Resources Act, and he was essentially performing a high-wire balancing act. On one hand, he had Section 2J, which explicitly requires restructuring the fishing industry to address historical imbalances. But on the exact same token, the law demands ecological conservation so we don't, overfish the hake into extinction, plus the protection of economic growth and those 8,000 existing jobs. The total allowable catch for the year is strictly capped. You can't just magically spawn more fish to keep everybody happy. They have a finite resource, but infinite demands.
An absolutely crucial point here is that transformation is not just optional. As Justice Ngugobo so powerfully noted, transformation isn't some political talking point. It's an active, binding constitutional commitment to eradicate the ongoing legacy of apartheid. He rightly pointed out that if you just cross out discriminatory laws but leave all the accumulated wealth, fleets, and infrastructure entirely in the hands of the historically privileged, well, you haven't actually achieved equality. You have to take positive action to redistribute that opportunity. But the million-dollar question is, how fast do you go, and at what cost to the stability of the entire industry?
Moving right along to Section 3, the reasonableness test.
So, how exactly does a court decide if a government official perfectly balanced all these heavy goals? Do judges just get out their calculators and redistribute the fish themselves? No way. Under the Promotion of Administrative Justice Act, or PAJA, the courts apply what's known as the reasonableness test. This is huge for what you should take away from this explainer today. A court does not ask, was this the absolute best decision? Instead, they ask, was this decision so completely unreasonable that no sensible person could have ever reached it? It's a threshold of absurdity, not perfection. And that gives the government official the necessary breathing room to do their incredibly complex job, provided they act rationally and weigh the evidence properly. Now, what did the chief director actually do? Bato Star claimed they were just brushed aside, but the mechanics show a highly systematic approach. The director took a cautious 5% cut from all existing players to create an equity pool.
Then, every single applicant was rigorously scored based on specific criteria: internal transformation, investments, labor practices, the whole shebang. Finally, that 5% pool was mathematically distributed to reward those with the very best overall scores.
And here is exactly where Bato Star's argument hits a brick wall of hard data. They argued they were ignored, right? But the data actually shows they were a below-average applicant. Overall, they scored a 4.9 out of 10. And on transformation specifically, they scored just 1.7 out of 4. Sure, they had strong black ownership, but they scored terribly on other critical metrics like workforce demographics and skill development. In fact, and this is wild, they were outscored on transformation by 77 other companies. That includes several of the old pioneer companies who had already successfully started transforming their internal structures. So that low score is directly why Bato Star got a smaller 856-ton slice of the pie.
Section 4. The separation of powers. This whole situation brings up a critical macro-level question. When should a judge step in and rewrite an expert government official's math? Well, the Constitutional Court had to grapple with the concept of judicial deference. Now, let's be clear. Deference doesn't mean the court is being timid, and it definitely doesn't mean blindly bowing down to the government. Rather, it means the court actively respects the constitutional separation of powers. It acknowledges that administrative agencies possess specific, deep expertise in highly technical issues. A judge might be an absolute genius in a courtroom, but they probably don't know the first thing about the migration patterns of deep-sea hake or the capital depreciation rate of a commercial trawler.
As the judgment brilliantly highlights, judges are the experts in law, but executive agencies are the experts in the highly technical realities of maintaining a 5.4 billion rand commercial fishing fleet. The court's job is simply to make sure the officials stayed within the legal boundary lines of reasonableness. If they did, a judge literally cannot cross that line and play chief director, even if they personally would have preferred, say, a 10% redistribution instead of a 5% one.
Finally, Section 5, the final verdict. Let's see how the Constitutional Court resolved this.
After years of litigation, the Constitutional Court unanimously dismissed Bato Star's appeal. They ruled that while a 5% shift might seem tiny at first glance, the chief director acted totally reasonably. Why? Because the deep-sea trawl sector is incredibly capital-intensive and economically fragile. If you destabilize it too quickly by ripping huge quotas away from established companies, you risk massive job losses, unserviceable debt on those billion-rand ships, and basically total economic collapse. The chief director reasonably decided that the safest way to transform the specific sector was to force the existing well-capitalized companies to transform internally rather than dumping all the quotas onto new entrants who frankly might lack the capacity to harvest the fish safely.
When we trace the timeline of this fierce legal battle, it's pretty eye-opening. The quotas were announced in 2001. By 2002, Bato Star actually won in the High Court, which threw the whole industry into total chaos. But then in 2003, the Supreme Court of Appeal overturned that. And finally, in 2004, the Constitutional Court had the absolute last word. It just goes to show that creating a fair, transformed society using administrative law isn't some quick overnight fix. It is a rigorously tested process where every decision has to hold up against the absolute highest standards of rationality.
I want to leave you all with this provocative thought today. As we look at the fishing industry and beyond, how do we carefully balance the undeniable moral imperative of correcting historical injustices against the practical economic survival of complex industries? Bato Star Fishing is such a brilliant reminder that the scales of justice aren't just weighing right versus wrong. A lot of the time, they are weighing two competing rights. The urgent need to fix the past, perfectly balanced against the practical need to protect the future. Thank you so much for joining me on this explainer, and keep asking those hard questions.